So good evening, everyone. Today we'll be presenting regarding the Nissan's corporate scandal from 2018 and which is still ongoing in present day. So the outline of our presentation, firstly, we will briefly introduce the key facts of the case, as well as highlight pertinent differences in US and Japanese corporate law. And thereafter, we'll introduce the breach of the duty of loyalty, as well as provide our recommendations, and then the breach of the duty to monitor, inclusive of this duty to report, as well as recommendations before making our concluding remarks. So the key facts of this case. 19 November 2018, Carlos Ghosn, who was then Nissan chairman of the board of directors, he was arrested on 2 charges of underreporting of income, both on 2 separate time periods. On January 2019, there was an additional charge of aggravated breach of trust. And on April 2019, this 4th charge of transferring Nissan funds to dealers in Oman. So essentially, all these 4 charges, they essentially constitute theft, and they highlight a breach of duty of loyalty on the part of Ghosn as chairman of the board of directors, along with a breach of a duty to monitor by other directors, and finally a breach of a duty to report in Japanese corporate law, which will be shortly introduced. So there are certain broad similarities between US and Japanese corporate law, and it is important to highlight that after World War II, the US ensured the revision of Japanese corporate law, largely based on Illinois law. So both corporate law systems, they cannot be said to be totally at odds with each other. And secondly, it is also worth noting that the US is a common law system, while Japan is a civil law system. So while preceding cases in Japan, they do not form binding legal precedents, we will still examine and attempt to clarify these duties in Japanese corporate law through referring to relevant landmark cases. So US, as we have studied in class, is a duty of care, as well as a duty of loyalty, which encompasses the duty of monitor. In Japan, similar to the US, there's also the duty of care. However, there are certain overlaps, similar to the US. In Japan, there's also a duty of loyalty. However, there are certain overlaps with this duty of loyalty with duty of care, which will be further elaborated in the next section. And in Japan, there's also the duty to monitor. However, this mainly pertains to execution of operations, which in brief notes that directors as a whole, they execute the operation of the stock company, and hence they may not delegate certain decisions to individual directors, for instance, appointment or dismissal of managers, which then implies that the board of directors need to jointly monitor the processes of the corporation. And finally, the duty to report, which is also another corporate law, which is also another corporate law clause under the Companies Act, which, however, explicitly refers to company auditors. And this duty to report, even while coming under the duty to monitor, was probably one of the most obvious differences in Japanese corporate law. So essentially, this duty to report relates to company auditors, the mandatory organ of a joint stock company, of which the structure will be further examined in relation to the subsequent part on duty to monitor. And they are essentially supposed to audit directors. And these company auditors, they have a duty to report to directors if they find that directors engage in misconduct or are likely to engage in misconduct. So now we'll be moving on to the duty of loyalty.
Thank you. Slide. The Japanese duty of loyalty covers the same goal as the United States duty of loyalty, but has some differences. One particularity is that sometimes duty of loyalty in Japan is not distinguished from other duties. In court cases, courts have referred to directors' breach of the duty of faithful care, which would encapsulate both the duty of loyalty and the duty of care. However, in terms of practical facts, the courts have been strict and clear. The Commercial Code requires that the directors shall comply with laws, ordinances, and the provisions of the Articles of Incorporation, as well as resolutions adopted at a general meeting, and shall perform their duties faithfully on behalf of the company. Courts have interpreted the Commercial Code to the letter and have found that if a plaintiff demonstrates that a director jeopardized corporate welfare for private gain, they will almost always find this conduct illegal. Theft is a very straightforward example of a breach of duty of loyalty, and this is what we will be examining in the case of Carlos Ghosn. Slide. There are 3 specific charges against Carlos Ghosn, and including his associate, Mr. Kelly. First, there's the underreporting of income, by which Ghosn and Kelly allegedly underreported Ghosn's income. Second, shifting of losses to Nissan. This is a more serious charge of aggravated breach of trust. Since it is direct theft, Ghosn was accused of having Nissan cover his personal exchange losses in the 2008 financial crisis. Finally, skimming of Nissan funds, in which Ghosn allegedly skimmed off $5 million from Nissan funds in a transaction to take these for his personal funds. These examples of theft fit quite squarely under the definition of a breach of duty of loyalty. And the duty of loyalty is considered to be well written and strictly upheld by the Japanese courts. So this raises questions as to why exactly these breaches take place. Several answers open up possible suggestions on how to avoid such scandals. One first question is the question of whether there are adequate penalties. Japanese courts have used very high penalties to discourage people from breaching the duty of loyalty, including prison time and very high fines. But it is important to remember that in the context of a director of a very powerful and wealthy company, such as Mr. Ghosn, there is a high incentive to steal if they think they can get away with it. However, considering the high penalties Japanese courts have instituted, it seems that the larger problem is why exactly these directors think they can get away with theft. A second main issue is the focus on individual directors and the concentration of power within a single person. Slide. One main reason that Ghosn was able to get away with these breaches of duty of loyalty is that there was focus of power in one director. First, Mr. Ghosn was appointed by the resolution of Nissan's board of directors to determine the compensation of the company's directors and top-line management, as well as his own salary. So he had the power to decide his own compensation, concentrated on only one director. Even more importantly, Ghosn managed to not share his compensation decisions with any other departments of Nissan, and nobody objected to this lack of transparency. Only Mr. Kelly, who was one of the directors and responsible for global human resources, was aware of the compensation decisions. He was charged alongside Mr. Ghosn for a breach of the duty of loyalty. Slide. However, another aspect that we cannot ignore is that these violations happened not only because of concentration of power, but also because no one monitored or questioned Ghosn's lack of transparency and power. There is a strong relationship between the duty of loyalty and the duty of monitor. Ghosn did not evade prosecution for so long because the duty of loyalty is too weakly legislated or enforced, but rather because he was not adequately monitored. Oversight and an enforced duty to monitor are essential to a healthy duty of loyalty, and the two are mutually reinforcing. Despite the fact that the explicit charges against Ghosn center on his breaches of the duty of loyalty, we argue that the real issue here is enforcement of the duty to monitor, and that recommendations on how to avoid breaches of duty of loyalty must center on oversight of the board of directors to prevent more scandals such as this one. The duty to monitor will be examined in the next part.
So now I will talk about the duty to monitor. So the wrongdoings have been conducted by Mr. Ghosn since 2010. Hence, there is a clear flaw in the effectiveness of the duty to monitor in Japanese corporate governance. Nevertheless, Nissan did not prosecute the board of directors for their failure to monitor. Director Ghosn and Kelly were the only two who were accused of breaching the duty of loyalty. No penalty was decided for the failure to monitor because the court considered that the board of directors and the statutory auditors were generally unable to prevent Mr. Ghosn's wrongdoings. In order to understand the failure to fulfill the duty to monitor, it's important first to present the different corporate governance structures in Japan. There are three corporate governance structures: the company with statutory auditors, company with an audit and supervisory committee, and a company with three committees. In order to analyze the duty to monitor in our case study, I will focus on the company with statutory auditors, which is the most commonly used in Japan, and its Nissan corporate governance structure. According to the Companies Act, in the company with statutory auditors, shareholders elect directors and statutory auditors. Then the directors decide representative directors among the board. Representative directors have general responsibility for the day-to-day management and operations of the company. Mr. Ghosn was appointed as a representative director. All directors have the duty to monitor the activities of the representative directors, and outside statutory auditors who are independent from the company must monitor the directors and audit the management of the company. The statutory auditor's purpose is to assure that all directors adhere to corporate governance laws, and they also have to review the company's financial statements. Although this corporate governance framework is the most common in Japan, domestic and foreign investors are increasingly reluctant to use it due to the recent corporate scandals in Japan with this form of business. Indeed, according to Masuda and Yoshiba, the biggest flaw of this corporate framework is that outside statutory auditors cannot effectively supervise the representative directors due to a lack of voting rights at meetings of the board of directors. So how did the board of directors and the statutory auditors fail to monitor Mr. Ghosn? So the strategy of Carlos Ghosn to evade supervision highlight the flaws of the duty to monitor in Japanese corporate governance. So according to the report of the Special Committee for Improving Governance at Nissan, Mr. Ghosn used many tactics to overcome monitoring. First, at the board meeting, Mr. Ghosn presented fake documents concerning his own remuneration. Nobody ever questioned these documents because he was appointed as the only director to choose on compensation. Although under the Companies Act, the directors can request board meetings whenever necessary to question management and ask for more information, other directors and the statutory auditors were never suspicious. The board meeting only lasted 20 minutes, according to the investigation. Hence, the directors and the statutory auditors didn't have the opportunity to debate and discuss on the management of the company. And paradoxically, suspicion was not present, also because Mr. Ghosn was highly regarded and respected in the automobile industry. Indeed, he was admired for saving Nissan when he was about to go bankruptcy. Moreover, he was the CEO and chairman of the biggest automobile alliance between Renault, Nissan, and Mitsubishi. Henceforth, he had a significant concentration of power, which made it difficult to correctly supervise and monitor his decisions. It's problematic that one director of the board of directors has so much authority. Theoretically, the board of directors must act as a group. The directors must not fully trust one director. Instead, they must be active participants in the decision-making process. It's quite a paradox that he was able to overcome monitoring, since the statutory auditor's only role is to exercise oversight over the directors. Thus, there's a clear flaw in the corporate system because the statutory auditors relied on the highly respected figure of Mr. Ghosn and neglected their monitoring duty. A more robust monitoring is required, and directors and statutory auditors must not only rely on one director. In fact, it is not the first time that Japanese companies witness corporate failure to monitor. Consequently, Japan amended the Companies Act in 2015 and added a new form of corporate governance called Company with Audit and Supervisory Committee, in which the Audit and Supervisory Committee is empowered with broader audit authority than the statutory auditors in the traditional model. So now we will talk about the recommendations to improve the monitoring in Japanese company with statutory auditors. So it must be clear that in the Companies Act, the board meetings of 20 minutes should be prohibited. Also, making administrative departments opaque must be outlined as a clear red flag for the directors and statutory auditors. Moreover, to refuse to disclose information to other departments and employees should be prohibited. Japan has to improve its corporate monitoring by encouraging the implementation of this new corporate form that I just mentioned above. And under the Japanese Corporate Governance Code, there is a rule called comply or complain, which we believe must be removed. According to this rule, the company can justify its non-adherence to the code, such as to limit the number of appointed outside directors to monitor the business activities. This should be removed to enhance the duty to monitor and supervision. It's also important that outside directors and the statutory auditors are required by their duty to monitor to drive the conversation and question every decision instead of just trusting representative directors at board meetings. For instance, the Companies Act could establish weekly meetings between representative directors, and the statutory auditors to improve communication and information flows. Moreover, there are currently no legal duties for employees under Japanese corporate law. However, many corporate scandals such as this one have been brought by employee whistleblowers. Due to the ongoing fear of being fired by reporting suspicious activities, Japan established the Whistleblower Protection Act, which prohibits a company from treating employees unfairly for reporting illicit behavior within the company. However, many scholars consider it to be too weak. In order to prevent future corporate scandals, employees should have legal duties, such as the duty to monitor, in order to have transparency and information shared at all times. Lastly, the need to punish the directors and statutory auditors for their failure to monitor must be reinforced, since punishment is essential to comply with the law.
So in conclusion, we've examined the 4 charges of Carlos Ghosn and how they have violated the duty of loyalty, as well as the duty to monitor, of which the duty to report is a subset. And it's worth noting that the upholding of each duty depends on the other. For instance, the duty of monitor is needed to uphold the duty of loyalty. Finally, we also note that overt focus on individual directors. For instance, Ghosn himself had the power to decide compensation by himself as one director, and there was a lack of ability for statutory auditors to supervise representative directors in reality, as they do not have voting rights in meetings, even if the Companies Act theoretically allows for their supervision. Accordingly, we have provided recommendations targeted to the issues outlined, both pertaining to modifying the relevant law as well as improving the structure of corporate governance as a whole. And with Carlos Ghosn's escape to Lebanon, it remains to be seen if the court's decision on how to ensure sufficient remedies to the scandal is appropriate, as well as relevant, appropriate, and needful measures in future in order to ensure that such corporate scandals do not become commonplace in Japan. Thank you.